Okay, in our previous session just a few minutes ago, we talked about the problem of duty. In particular, do you owe the person a duty at all? Or are they so remote that you do not owe them a duty at all? And we talked about if you do owe them a duty so that that person becomes a foreseeable plaintiff. If you owe them a duty at all, how much duty do you owe them? Due care under most circumstances, extraordinary care under a few circumstances that we talked about, and the duty to make safe if the activity is ultra hazardous. We talked about how to use Restatement 520 to determine whether or not an activity is ultra hazardous. We talked about how to use the common law to determine if an activity is ultra hazardous. And I might mention quickly two other methods. One is keeping undomesticated dangerous animals. You keep a lion, strict liability. We know about that one. And the one other case of strict liability that isn't followed by very many states anymore is the Rylands versus Fletcher case. This is the case where Fletcher had made an artificial lake on his land, filled it with water. The water percolated down through the soil and into the mining operation of Rylands. So Rylands' mining operation was damaged by the artificial lake that Fletcher had created. And so Rylands sued for the damage to his mines. The rule that comes out of the case is that if you bring a substance onto the land, like the water in that case, which is not the way the land is normally used, like the water in that case. And the nature of that substance is that if it escapes, it may cause harm. That's the water. And if it does escape and cause harm, the water did, then the person, in our case, Fletcher, is strictly liable for the harm caused. And that's what comes out of that case. Now, you can see, although that's a very minority position, that you could have used it also in the escaping fumigation gases. That's not that different from the escaping water in the Rylands case. You could use it in the case of the escaping viruses in the viral research, cattle viral research. Could have used it there. So those are two other methods in which you can, so to list all the ways you can determine that the defendant is strictly liable, they are the common law method, the Restatement 520, keeping undomesticated dangerous animals, and under the Rylands versus Fletcher doctrine. To summarize, to whom did you owe the person a duty at all? If you did, how much duty did you owe them? And the next question, of course, is whether or not the duty was breached. Now, one peripheral comment that I want to make is that when we were here dealing with this problem of whether or not a particular plaintiff is too remote to be foreseeable or not, is this a foreseeable plaintiff when we were talking about those issues, I want to point out, and we also talked some at that time about proximate causation. And we pointed out how the people behind you on the freeway after a simple fender bender accident, that you are not liable to those people for their loss of time, and that lack of liability to the people behind you on the freeway is explained in several ways. And let me summarize those for you again before we get on with breach. So we're talking about, does the person who has the fender bender accident on the freeway who now has all these people lined up behind him who lose time. Can those people sue? We know they cannot, but we're looking for all of the legal theories that are applied to that problem. And I'm saying one of the legal theories is that you simply do not owe a duty not to cause that kind of a delay to those people behind you on the freeway. So they can't sue you because you didn't owe them that duty. On the other hand, if their vehicle or personally, if they were injured in that accident, you do owe them a duty not to negligently cause those injuries. You don't owe them a duty not to cause them time delays. And so if they are injured or their property is injured, then you do owe them a duty. Otherwise, you don't. So that's one way the legal system cuts off these people lined up behind you on the freeway. Another way to cut them off is at the proximate causation level. And at the proximate causation, the key thing I want to point out to you here is that the question of who is a foreseeable plaintiff, that question arises before the defendant has breached whatever duty they breached. Before they breach that duty, the question is that person a foreseeable plaintiff? Okay. After they have breached the duty, now the harm ripples out, and the question is how far out that ripple does the person remain liable? That is the proximate causation problem, which occurs after the defendant has done something wrong, breached their duty, whatever their duty was. And so to cut out these people lined up behind you on the freeway, to cut them out, some states will cut them off at no duty owed to them, and some will cut them off at the proximate causation, saying that when you have, even if you breached your duty by having the accident, that we say that their injury is too remote, not foreseeable in the sense of legally foreseeable, not proximately caused. So they cut it off after the accident has happened, saying the harm is not proximately caused. A third way that people deal with this problem of the people lined up behind you on the freeway are similar analogy problems that we talked earlier about. The way to cut out liability to them is some jurisdictions will say that the defendants are not liable for pure economic harm. Pure economic harm, not liable for it, meaning that the people who are lined up behind the accident on the freeway, all they have is pure economic harm, unless their car crashed or something like that. And so another way people deal with that is they say the defendants are not liable for pure economic harm. So that's how those issues are dealt with. And one last point I want to make before we move on to breach of duty, and that is we talked in the last hour about this train company called Transco, where these trains were going down carrying toxic materials, and the train derailed and damaged some nearby property. The point I want to make is that we know that the train company owed certainly a duty of due care to the people whose property was near the tracks. They at least owed them a duty of due care if this was an ultra-hazardous activity, hauling these toxic materials. Then the train company owed these people with property along the train tracks a duty to make safe. Okay, but the point I want to make, the final point, is that this duty of extraordinary care that common carriers owe, they owe that duty of extraordinary care to their own passengers. They don't owe it to the people out there in the streets. So that a taxi cab driver owes a duty of extraordinary care to the passengers in the taxi cab, but at the traffic stop they don't owe you anything more than just an duty of ordinary care. And so this train company where the train derailed did not owe a duty of extraordinary care to the people who had nearby property. They just owed them either the duty to make safe or the duty of ordinary care, but not extra, because they only would owe that to passengers on the train, and there weren't any. Now, with all that in mind, we want to get on with breach. we mentioned that when the duty is to make safe, the breach is dirt simple. When the duty is to exercise reasonable care or even extraordinary care, that's a much fuzzier boundary. Did the defendant exercise reasonable care or not? It's clearly a fuzzy boundary. And here are the rules for dealing with that fuzzy boundary. And the bar examiners will want to know if you know these rules. The rules are there are basically 5 ways to determine, 5 and only 5 ways to determine whether or not the defendant's conduct breached the duty of ordinary care. Was it negligent conduct? Remember, that's what negligence is. Negligence is simply the breach of duty. Just these 2 parts right here, breach of duty. That constitutes negligence. The cause of action, to get money for negligence, you need all the other stuff. But negligence and breach of duty are interchangeable expressions. And so the question is, how do you decide whether or not the defendant acted with reasonable care? Fuzzy boundary, how do you deal with it? Here are the 5 ways that you're expected to know, that the bar examiners want to know if you know, for dealing with that fuzzy boundary. 1, did the defendant violate some rules of conduct? And the specific rules are here. We'll come back and talk about this one. Did the defendant violate some rules? This is actually rules of conduct. Second way of dealing with the question of did the defendant's conduct breach the duty of reasonable care is, did the defendant violate the standards of a profession or skill? What does that mean? Well, what it means is that when people are engaged in a profession or skill, they usually have co-workers. There are other plumbers, there are other electricians, there are other brain surgeons. And when people are engaged in a profession or skill, we lay people don't really know what it is they should and should not do in order to be reasonably careful. I don't know what a brain surgeon should and should not do in order to be reasonably careful. And so what do you do in those cases? And the answer is, what the bar examiners want you to understand is that what you do, and they test this lots of ways, what you do is you look at the profession as a whole. You look at brain surgeons, you look at plumbers, you look at electricians, and you say, what would other electricians expect this electrician to do under these circumstances to constitute reasonable care? What do these other plumbers expect a plumber to do to exercise reasonable care in this situation? What do other brain surgeons expect a brain surgeon to do in this situation in order to be reasonably careful? So that's how we set the standard. We find out what other members of that profession expected of this person, expect them to do, the minimum that they expect, not the nicest, most maximum, safest, greatest, but we're talking about the minimum that you expect a person to do under these circumstances to constitute reasonable care. And whatever the profession expects, that's what we adopt as the standard. And the way you deal with that in real life and on the bar exam is you bring on an expert in that profession or skill. Okay, you bring on a brain surgeon, a plumber, an electrician, and you say to the plumber, when you are connecting pipes made of different metals, you know, what do you expect plumbers in good standing in your community, what do you expect them to do in order to be reasonably careful under these circumstances? And the expert plumber would say, oh, in my profession, everybody knows not to connect these incompatible pipes. We always use a plastic connector or something to do that with. The brain surgeon says, oh, everybody knows that when we're doing that kind of a procedure that you always do X first because it might be bad. And so you establish the standard of the profession in that way. And then the second step, after you've established the standard, that's step one. And that's what we're talking about here, a violation of the standards of a profession or skill. And so the first thing you have to do is to establish the standards of the profession. That's how you establish them, by putting an expert on. And you say, dear Ms. Expert, you know, are you an expert in so and so? Oh, yes, I'm the expert. And so then you say, then, you know, what do people, and not what do you, Ms. Expert, expect, but what do people in your profession expect? That's the standard. Now you look at the conduct of the defendant and you ask, did the conduct of this plumber, this electrician, this brain surgeon, did that conduct fall below the standard that has just been set by bringing on the expert? And if the conduct fell below that standard, we say this person this person violated their duty to exercise due care, because the profession says we don't do that, that's too dangerous. So that's how we do it. Now, a couple of cautionary things in here. One is that sometimes you don't need to use any sophisticated mechanisms to show that the physician, for example, was negligent. The person goes in for an operation on one leg and the physician cuts off the wrong leg, or the surgeon cuts off the wrong leg. You don't need experts, okay? Everybody knows that's negligence. And so in other circumstances like that, where you don't need the expert to set the standard, because the ordinary common understanding sets the standard. So violation of the standards of a profession or skill, the plumber did it in our plumbing example. The next one is the balancing test. Now, the idea behind the balancing test is that if you examine someone's conduct by saying, how much risk does this conduct create? Driving fast, forgetting about, you know, criminal statutes and stuff, but driving fast or going through stop signs, that sort of thing. Let's take the case of an ambulance, a speeding ambulance that goes through stop signs and does all kinds of strange driving with the sirens going. This creates some risk of harm. So we look at how much risk is created by this defendant's conduct, our speeding ambulance in my hypothetical. And then we weigh the risk that was created by this person's conduct against the justification for the risk. And in the case of the speeding ambulance, the public would say, yeah, that risk is justified. In the case of the speeding fire truck, they'd say, yes, that risk is justified. And so in the balancing test, what you do is you find a way, and I'll show you how it's done in a minute, you find a way to sort of measure the amount of risk that was created by the defendant's conduct, and you weigh that against the justification for the risk, and you say, in effect, if the risk was justified, then that's a reasonable risk. And if the risk was not justified, that's an unreasonable risk. So really you're measuring the risk against the justification for the risk. So the question then under the balancing test becomes, well, how do you measure the risk and how do you measure the justification for the risk? And let me show you that. I'm going to we've already used this side of the board, so I can erase this now. And we're looking at the balancing test right here. And under the balancing test, what you do, and I'll put a little drawing here, what you do is you weigh the risk versus the justification. Okay, this is what we're doing with the balancing test. We're weighing the risk against the justification. So the question becomes, how do you measure the risk and how do you measure the justification? Here and here, and this is what we're about to do now. Let's begin by making a larger diagram. This side is the risk. Let me mention that this method has several names, and let's be sure that you know all the names. This is called the balancing test, risk balanced against the justification for the risk. This is also called the Carroll-Towing test because it came in the famous case of U.S. versus Carroll-Towing. So it's called the Carroll-Towing test. It's called the Learned Hand test because Justice Learned Hand was the one who wrote the opinion that contained this. It's called a risk utility analysis, okay, all that stuff. And so it's all the same stuff. We basically are going to weigh the risk against the justification for the risk. So the question becomes, how do you determine the risk? And how do you determine the justification? And then we want to see several examples of how this got tested on former bar questions. Here under risk, how do you measure the risk? It's in two parts. Part one is the likelihood that the event will occur, likelihood of injury. And this is also called the probability of injury, the probability that the event will occur. Same thing, probability that the event will occur. This is multiplied conceptually by the gravity of harm if harm should occur. If the harm occurs, how bad will it be? And so what this method does is to say the way we measure the risk is we look at how bad would it be if it happened, and we multiply that by the probability of it occurring. Now, probabilities are always a number between 0 and 1. And so if you multiply the gravity of the event by something less than 1, it's going to reduce the overall outcome. And in fact, the way Learned Hand wrote the test is he said it is the probability, is the gravity of the harm reduced by the probability of it occurring. And what he means is multiplied by the probability, and that's going to reduce the value. So that's how we determine the risk. Now let's look at this for just a second and consider the case where we have some very high risk and very high, where we have some very high harm and a very high probability of it happening. Let's look at those cases. Terrible event, highly likely to occur. The other end of the spectrum of risk is where you have a very low consequence and a very low probability of it happening. That would produce, of course, the lowest risk. And the risk in between is where, for example, you have some terrible event harm is grave, but the probability of it happening is very small, then that would give you a risk that's someplace in the middle. If the gravity is large, but the likelihood is small, you end up with a risk someplace in the middle. Likewise, if the probability is high, but the gravity is quite small, you end up with a risk someplace in the middle. And so the risk, in order to give a dramatic impact on the jury when you're using this method, the times when you'd want to use the method is when you can get a very high risk where both of these are large. Then you can show the jury how awfully high the risk is and let them try to justify that kind of risk. On the other hand, if you have a problem where the combination just gets you kind of middle of the road risk, and they're going to obviously produce some kind of justification, sort of middle of the road justification. So this method isn't going to really give you a dramatic result unless you get one of these, either the risk or the justification, to go to the extreme. Let me give you a couple of examples from real bar questions so you can see what the risk looks like. One question is the transco question that we talked about earlier, where the train company was hauling toxic materials, and Diana had done some research for them saying whatever her research said. But the key thing here is that we are now about to sue the train company, Transco. These are the people who had property, who have property near the train tracks. And you recall what happened is that the train company had an engineer. The engineer had had a heart attack 5 years ago. The engineer was obese right now. The engineer was driving this train carrying toxic materials. The engineer had a heart attack. The train derailed. The people who owned the property near the train track were damaged. And one of those plaintiffs is Paul. Now, when we decided earlier that Diana did not owe a duty to Paul, but Transco owes a duty to Paul. Paul is clearly a foreseeable plaintiff. Train company is hauling goods, and people with property near the tracks are foreseeable plaintiffs. Now, so Paul is a foreseeable plaintiff, and so they owe him at least a duty of due care. Not a duty of extraordinary care, just a duty of due care. And so did they breach their duty of due care? If Paul is going to sue Transco, they got to show that Transco breached their duty of due care. What did Transco exactly do? Now, it's real important in these problems, when you're going to sue for negligence, that you identify the very conduct that you claim is the negligent conduct, because that's the conduct that you have to evaluate and decide whether or not that conduct was negligent. So you have to really focus and identify exactly what the conduct is that you're claiming was negligent conduct. In our case with Transco, we're saying what Transco did was to assign this person to drive this train given that background, and that creates an unreasonable risk of harm. So you identify what Transco did, what I just said they did. Transco did that, and you claim that that was negligent conduct by Transco. How are you going to prove that was negligent conduct by Transco? Well, let's take a look. The way you prove negligent conduct, we come here, first of all. We talked briefly about rules of conduct. Transco hasn't violated any rules of conduct. There's no law against what they did. So you can't use violation of rules of conduct to find that what Transco did was negligent conduct. Assigning this train driver to drive that train, we say that was negligent, but you can't prove it this way. How about this way? Did Transco violate standards of a profession or skill when it assigned this train driver to drive this train under the facts that we talked about? No. They were not engaged in any people. Individuals have professions and skills. I don't think a company even has professions or skills. In any event, that won't work. Balancing test. This is where we are now. We're going to use the balancing test. The balancing test says, well, we will look at the risk created by Transco's conduct and we'll weigh that against the justification. So let's go to our larger diagram and do that. Here, dealing with a Transco problem, if the train driver has a heart attack while driving the train, how grave would that harm be? And you put some words in there of your own choice, such as enormous property damage, perhaps great bodily harm or death could occur. So you would say how grave the harm could be if the train derailed carrying these toxic materials. What is the likelihood that this event will occur? Well, we really are asking what is the likelihood that this person will have a heart attack while driving the train. And here you make the most of the fact that, what they knew about this person's history, there is some significant risk of that, and that when you combine that significant risk with the enormity of what could happen, there's a significant likelihood or probability that the person would have a heart attack while driving the train. There's some reasonable probability that that will happen. And the harm would be enormous. And you would say that constitutes a very large risk. Again, the points here are not in the label you put on very large risk, huge risk, what label. The label is on the points are and you're describing the risk. So, and then you can say whatever label you want to it. But you describe the risk. A person may have a heart attack while driving the train, and that's an enormous risk. Can the train company justify that risk? Well, let's see. How do you justify risk? There are two components to justifying risk. They are, number one, the burden of prevention. How hard is it to prevent this type of harm? And if the burden of prevention is very high, of course, that provides some justification for not preventing it. The second factor, which is added, not multiplied, added, not multiplied, the second justification is the social utility of the defendant's conduct. Social utility. By social utility of the defendant's conduct, we're asking kind of the rhetorical question, what is society getting out of allowing this person to create this, whatever risk they're creating? What is society getting out of allowing a fire engine to run the stop signs or the red lights? Okay? They're creating some additional risk when they do that. But what is society is getting something back for that. The same thing with a speeding ambulance. Any speeding emergency vehicle creates some additional risk, presumably, but society is getting something back for it. That's the social utility of the defendant's conduct. Let's look at our case with Transco. Okay, what did Transco do? They assigned this train driver to drive this train under the circumstances we talked about. And we say that creates a very significant risk, and we described what that risk was. And then we say, can you justify it? What is the burden of prevention? How difficult was it for a Transco to assign somebody else to drive this train, or to have this person do a desk job or something of that sort? Doesn't seem like the burden of prevention was very high at all, just a scheduling problem. Social utility. What is society getting out of allowing the train company to make these kinds of risky assignments? And society isn't getting anything out of that. So the justification is very small. Enormous risk. When you weigh the risk against the justification, the conduct of the train company was negligent conduct because they created far more risk than could be justified. In fact, you can pick up additional points here by noticing that when the risk is much higher than the justification, can't you maybe call that reckless conduct? When people create a lot of risk and there's almost no justification, that is arguably reckless conduct when they're that large. And so you can make that argument. Let's look at another one of these risk versus justification examples. We just did Transco, and we understand how you could use this method to show that Transco acted negligently. Let me give you another bar example about this same problem, where you can use the same, you're expected to use this same analysis. In this problem, a driver was driving a car along the road with a passenger, Peter, in the car. The driver came to a sharp turn in the road, and on a dark, clear night, failed to successfully negotiate the turn, went off the road, and hit a power pole. The driver says he does not know why the car went off the road. He wasn't speeding, and they had no evidence to suggest he was. He does not know why the car went off the road, but it hit the power pole. Peter was in the car as a passenger. Peter was injured. Peter was unconscious. A fellow in a car later came along, a rescuer, saw what was happening. They tried to get Peter out of the car. Peter was unconscious. But before the rescuer and the driver could get Peter out of the car, along came another car driven by a person named Reckless. And this car hit the first car that was partly on the road because it had hit the power pole. And now, by the time they got Peter out of the car and by the time the ambulance got there, Peter was dead. One more important fact. The electric company who owned the power pole that just got hit, the evidence shows that this electric company knew that this power pole had been hit 3 times during the last month. And this is the 4th time it's been hit in the last 2 months. The last time it was hit, they hit it so hard they broke it. And the electric company had to reinstall this electric power pole, and they put it back in the same location, even though this was the 3rd time it had been hit within 2 months. And whoever hit it the 3rd time probably got killed because the pole was broken. And they reinstalled the pole in exactly the same location. And now along comes our driver. This is the 4th car to hit the pole in 2 months, and hits the pole, and Peter is dead. Now, the question, we're now going to sue Peter's executors are going to sue electric company who put the power pole down in this location. So we have to prove duty, breach, causation, damages. So if you're representing Peter, you've got to show, first of all, that Electric owed Peter a duty of due care. Electric must owe Peter a duty of due care. Well, you say when Electric put that power pole down there, they owe a duty of due care to all foreseeable plaintiffs. And that people coming along that roadway are foreseeable plaintiffs, particularly when the pole's been hit 3 times already in the last 2 months. And so the people on the road, including passengers in the cars, are all foreseeable plaintiffs. And so Electric owes these foreseeable plaintiffs a duty of due care. And in fact, in some jurisdictions, remember that when public utilities are engaged in their public utility activity, they, in some states, owe a duty of extraordinary care. And here, installing its electric power pole is engaged in their public utility activity. So they may have owed people on the roadway a duty of extraordinary care, but they at least owe them the duty of ordinary care. And so they owed that to Peter, the passenger. Did they breach that duty? Well, let's see if we can establish whether or not Electric breached its duty. First of all, did Electric, in putting that, first let's identify the very conduct that we're claiming was the negligent conduct of Electric, because you cannot evaluate Electric's conduct unless you clearly identify the conduct you're going to evaluate. We claim that putting that electric pole back in that location, given the facts that they knew at that time, we claim that that was negligent conduct. How can we prove it? First, did that conduct violate any rules? No, no statutes or city ordinances or anything. Secondly, did it violate the standards of any profession or skill? Well, you know, you can argue that there are lots of electric companies throughout the United States who have power poles near highways. And there might be some kind of a standard of the profession about where you place these power poles. And you can make an argument similar to violating standards of a profession or skill if there were such standards that had been violated here. You can volunteer 2 sentences about that. Don't waste a lot of time because you weren't given the facts. Next, we're still trying to prove that the conduct of Electric was negligent. Electric did not violate any rules. We'll have a stretch to try to find that Electric violated standards of its own profession or skill. Let's use the balancing test against Electric. Let's try that. Well, let's go over here on the board where we've got that. First of all, we're going to weigh the risk created by what Electric did, put that pole back there, against the justification for that risk. How do we measure the risk? The gravity of harm. Well, the gravity of harm in this case, how serious would it be if the pole got hit? In other words, if they're putting this pole back in the same location, we're saying that's negligent conduct because somebody might hit it. Well, how bad would it be if someone does hit it? I think the answer is great bodily harm or death. People hit power poles on the highway. And so the gravity of the harm that Electric is creating is great bodily harm or death. How likely is this to happen? Well, it's happening every 2 weeks. Okay? Every 2 weeks the pole gets hit. And so there's a very high likelihood of great bodily harm or death. That's a huge risk. But we describe it. We don't just put our own little neat label on it. We describe it. The points are in your description of the risk, not the label you put on it. Okay. So we've described the risk in this case for Electric putting that pole back in that location. Justification for the risk. Well, let's take a look. Burden of prevention. How hard was it or would it have been for electric to put that power pole further off the highway? My answer, apparently not very hard. It was already down. Say a few words about that. Social utility. Now, mind you, we're talking about the social utility of the very conduct that you're suing about. Now, I realize that electric is providing electricity for the free world and all that. But you're not suing them for providing electricity for the free world. You don't sue doctors for practicing medicine. You don't sue drivers for driving a car. You sue them for the particular thing that they did wrong. And here you're suing electric for putting that pole back in that location under these facts. And the question under social utility is, what is society getting out of that conduct? And the answer is society isn't getting anything out of that conduct. And so electric, by putting that power pole there, was creating an enormous risk, and they have almost no justification. Burden was slight, no social utility, almost no justification. Clearly, the risk outweighs the justification, and therefore the conduct was negligent. In fact, since this is a public utility, and they might owe a duty of extraordinary care, and if they do owe a duty of extraordinary care and yet created this much risk with very little justification, that is reckless conduct. And a lot of jurisdictions will allow you to get punitive damages for that. And that's worth points on your exam question. So we see how to use this mechanism. We see that when one of these, like the risk is very high, you get a dramatic result. And that's what you want. When you have either of these is small, you're not going to get a real large risk, and so the result is not going to be dramatic. And you can point out to the bar examiners that this is not the person's best theory. There will be other theories that you can also use. Okay, so we see how this doctrine works. You recall that we were looking at showing how duties were breached, and so far we've talked about breach of duties by violating rules of conduct, although we have not had good examples yet. We will shortly. We talked about breaching duty by violating the standards of a profession or skill. We talked about breaching duty by using the balancing test. It works well when the risk is very high. We're going to take a break, and when we come back, we'll talk about establishing a breach by using res ipsa or just reasonableness. On the other hand, let me review where we are, just to be sure we are together. We've had no examples where the defendant breached his or her duty of care by violating rules of conduct. And we're going to have an example in just a few minutes. Violations of standards of a profession or skill. We had the plumber. You recall that the plumber connected these two incompatible metals together without putting a plastic connector between them, and that was a violation of the standards of a profession or skill. The balancing test, we had two examples of that. We have Transco, who put the train conductor, assigned that job to the train engineer, Transco. And we also have Electric, who put the power pole back in that location when they knew how often it was being hit. So we have two examples of this, one example of this. And we're now, let's complete these next two, and then let's take our break. Let's start with res ipsa and with reasonableness. Now, let me tell you about reasonableness first, because this, put it up here. The reason I want to move it there will be obvious in just a few minutes. But I want to emphasize something about this whole structure here, and that is that what the legal system is attempting to do is to say that people ought to behave in a way that is reasonable under the circumstances. That's the basic concept. We all know that. Do not create unreasonable risk of harm. It's just that in a number of circumstances, like engaging in a profession or skill, the way the standards get set is instead of everybody kind of knowing what's reasonable, you have to look to the profession to see what's reasonable. But if you're not involved in a profession or skill, most people can look at a situation and say what's reasonable conduct. On the other hand, if there are rules that say what's reasonable, then those rules become important. That's another way to figure out what's reasonable. But always underlying this whole concept is that we're looking for what is reasonable conduct. And if there are circumstances such as profession or skills, or there are rules you can use, that helps to establish reasonable conduct. But in the absence of any of that, juries just use their good judgment about what's reasonable. This means that in the vast majority of cases, what you are arguing to a jury is you're saying, ladies and gentlemen of the jury, here is a circumstance that we're all familiar with. Now, don't you agree that reasonable conduct under this circumstance requires thus and so? So you're asking the jury to use their own concept of what's reasonable. And that's how most cases are litigated. These special circumstances where, the special situations where there's a standard or profession or there's a rule of conduct, or it's often you can use the balancing test. You can use the balancing test anytime, but it just isn't going to make a dramatic result unless you've got a high-risk situation. So I'm saying to you that all of these really are just devices for trying to measure against reasonableness. So the bar examiners could give you a situation where you could honestly say to them, look, everybody knows that this conduct is unreasonable, and you don't have to do much more. For example, on my 1,000-acre ranch, one of my many 1,000-acre ranches, if you're on my ranch and you're driving on an old dirt road at 100 miles an hour, okay, you're not violating any laws because you're on private property. Okay, you're not engaged in a profession or skill, but everybody will understand that that is dangerous conduct. That is unreasonably dangerous conduct. And so you don't need these fancy tools in cases like that. So I'm saying don't forget that all these tools are just to sort of help figure out what is reasonable conduct under the circumstances. But the reasonableness is there all the time. Now, the bar examiners are not going to give you this one because in this case, the reasonableness, all you get to do is to say, everyone understands that that is not reasonable conduct to drive 100 miles an hour on a dirt road on the ranch. And then I can give you that one, okay? You don't have to go to law school to know that. They're going to give you the ones where you have to use some of these special tools. But you might have an opportunity on the bar exam to add this one to the rest of your tools. You can use it. But when you use it, if you do, you must remember something very important. State the standard. Don't just say, this person's conduct was unreasonable. Okay, no. You got to do it rule application. So you'd say the rule is that a person is to exercise reasonable care under the circumstances. The jury gets to decide what is reasonable care. That a jury would realize that reasonable care is, do not create unreasonable risk of harm. Driving 100 miles an hour on a dirt road creates an unreasonable risk of harm. And therefore, this person has breached their duty of due care. Something like that. So Don't just state a conclusion. Lay out a standard of reasonableness and then work against that standard is what I'm trying to say. Finally comes res ipsa. Now, in all of the cases we have dealt with so far, up to this point, when you move reasonableness up to right here, in all of these 1, 2, 3, 4 cases, what we are always doing is evaluating someone's conduct. We are evaluating conduct. When someone is engaged in conduct that violated a rule, that's evaluating their conduct. Someone engages in conduct that violates the standards of a profession or skill, that's evaluating their conduct. Someone engages in conduct that creates more risk than you can justify. That's a method of evaluating conduct. Someone's conduct is that reasonable people would agree that that conduct creates unreasonable risk of harm. That's evaluating someone's conduct against the general public reasonableness standard. And so in all of these cases up to this point, we are evaluating conduct. And what is different about res ipsa is that we are now going to evaluate circumstances instead of conduct. In res ipsa, we evaluate circumstances, and that's what's different about res ipsa than the others up to this point. Example, let me suppose that you are driving along the road and you're on an interstate highway and you come up over the ridge, and just as you come up over the ridge, off the road to the side there is a vehicle that's upside down, on fire, and people are crawling out of the vehicle as fast as they can. It's more likely than not somebody was negligent. You don't know who it was yet, but somebody was probably negligent. So my point is that there are some situations where the facts themselves, you didn't see the conduct, but you see that the facts speak for themselves, that somebody most likely was negligent. And so the first requirement for using res ipsa is that, the 3 requirements of res ipsa are that the facts would lead a reasonable person to conclude that somebody more likely than not was negligent. You see the burning car when you come up on the road, and more likely than not somebody was negligent. Secondly, the facts need to be such that more likely than not it was this defendant. Now the old rule said this defendant had to have exclusive control of the instrumentality of the injury. But everybody's loosened that up now. All you need is that more likely than not it was this defendant. Now, so when you come up on this burning car, you say more likely than not somebody was negligent. You don't know whether it was the driver or the tire blew out or what happened. And so you can't say more likely than not it was any one person. So res ipsa wouldn't work so well. But if you could see that it was something foolish that the driver had done that led to this accident, then you could say more likely than not it was this person. So res ipsa has 3 requirements. First one, more likely than not somebody was negligent. Second one, more likely than not it was this defendant. Third one, the plaintiff is not contributorily negligent. Plaintiff was not contributorily negligent. The classic case of res ipsa was the barrel that fell out of the 2nd-story window and hit someone on the sidewalk down below, and the person down below doesn't know what happened up there, but they can say barrels don't come out of windows unless somebody up there more likely than not was negligent, and more likely than not that somebody up there was one of the employees of the owner of the little factory. And so under respondeat superior, more likely than not, it was that factory owner. And so, and the plaintiff walking on the sidewalk was not contributory negligent. So there's your res ipsa. In our problem for today, we had an example of res ipsa. Remember the driver who was driving the car along the road and came to the sharp turn and ran off the road and hit the power pole. And the driver says, gee, I don't know why the car ran off the road. I wasn't speeding. And so this driver, you know, you might claim res ipsa if when the passenger in the car named Peter sues the driver for the driver's negligence, the passenger would say against the driver that cars don't run off the road unless somebody was more likely than not negligent, and more likely than not it was this driver who was negligent and ran it off the road. So when Peter the passenger sues the driver, Peter the passenger could use res ipsa against the driver. There's one other example where you might have used res ipsa in the problems that we dealt with. Remember Transco that put this conductor, this engineer who was obese and had a heart attack recently, driving the train, had a heart attack, the train derailed. Well, if you are the person whose land was damaged by this toxic material was spilled on your land, your name is Paul, and you sue Transco, the train company, you could use res ipsa. You could say, trains don't normally go off the tracks and derail unless somebody was negligent. And more likely than not, somebody was the train company, some employee of the train company, and under respondeat superior, that's the train company. So you could use res ipsa there to show that Transco acted negligently. We then have, to summarize, we have at least two examples of res ipsa. One example of res ipsa is when the train ran off the tracks, that you could satisfy all three elements of res ipsa. The second example of res ipsa is when the car drove off the road, hit the power pole, and couldn't explain how that happened. So we have two examples where you could have used res ipsa and should have used it. Now, this leaves us with just one more category, and this is violation of rules of conduct. Let me tell you about these. First of all, there are two classes of these rules of conduct. One is this whole doctrine, this negligence per se doctrine right here. And quite separately from that is are these other rules down here. Let's talk first about the negligence per se doctrine here. The negligence per se doctrine says if the government passed a statute, not a city ordinance, but a whole statute, for the purpose of protecting a certain class of plaintiffs against a certain type of injury. They passed a statute and made it a crime to do that bad thing in order to protect these people, then you can see how when a person commits that crime and the person gets injured, that negligence per se is a reasonable doctrine. That is to say, to have violated that statute is negligence per se. Stop sign. The purpose of the stop sign is to protect pedestrians who are crossing there. Somebody runs a stop sign and hits a pedestrian, negligence per se. Okay, you have a criminal statute. The purpose of the criminal statute is to protect this type of plaintiff, the pedestrian at the stop sign, against this type of injury, being hit by the car, and they made it a crime to violate that statute, running the stop signs a crime, that's negligence per se, meaning that you can call it a conclusive presumption of negligence, if you like. Negligence per se, irrebuttable presumption of negligence, they all say the same stuff. So that's the negligence per se doctrine. It applies to state statutes. It does not apply to city ordinances. Next, violation of company rules or city ordinances or even custom in the community. These result in evidence of negligence, not negligence itself. So if all you have now is evidence of negligence, in order to get full credit, you must go to the other side and look at what evidence of due care is there. Okay, if you've got, if there's a company rule that was violated, that's evidence of negligence, or there's a city ordinance that was violated, where it was created to protect this kind of plaintiff, and those were violated, that's evidence of negligence. The other side's going to put in evidence of due care. So be sure to recite that and then compare. And the way you compare, you've got evidence of negligence, you've got evidence of due care. You do two things to get all the points out of it. Thing number one you do is you say, who has the burden of proof? You say the plaintiff has the burden of proving negligence. And you say how much that burden is. Is it beyond a reasonable doubt? Of course not. This is a civil case. Is it clear and convincing evidence? Nah, you just need those in a few cases like fraud and stuff. Preponderance of the evidence. And so you say the plaintiff has the burden of proof with the preponderance of evidence of that the defendant's conduct was negligent, and then you reach your conclusions of what you think a jury would say. Okay, but you've picked up points by saying who's got the burden of proof and and what the standard is. Nobody cares what your conclusion is. And so when it's here, pick up those extra points by putting in evidence of due care and evaluating it in the way I just said. The couple of examples of this, in the problem where the driver was driving late at night and came to a sharp turn in the road and hit the power pole. In that case, the driver did not have a valid license. In fact, the driver's license had been suspended for drunk driving, and he was driving without a license. Now, the writers of the question gave you an opportunity to jump wrongfully at that and say, well, these people were violating a criminal statute, driving without a license. That's negligence per se. Well, that would be a bad analysis, because the driver's license statutes were not created in order to prevent any particular accident. They're prevented to make the roads generally safer for everybody, so that you can be fairly assured that everybody out there on the road knows the rules reasonably well. Be havoc if you could let people just start driving anytime they wanted to without sort of meeting a certain standard. And so that's the purpose of the driver's license, is not to prevent any particular accident. So the fact that this person was driving, this driver in the electric pole case, was driving without a license, okay, it does not create the negligence per se, is not a case where you use the negligence per se. But you needed to explain to the bar examiners why. Another example of this was a case where in the question, the guy owned an apartment, or rented an apartment, and had left his apartment that morning on his way to work. And when he left, there's some gas that was escaping into his apartment, but he went to work anyway. In the middle of the day, his girlfriend came by the apartment. She had a key and used her key to unlock the door. But at the time that she opened the door, she was smoking a marijuana cigarette. And of course, all pandemonium happened. And so now you have a person who was violating a criminal statute, smoking the marijuana cigarette. But the purpose of the criminal statute was not to prevent fires. The purpose of the criminal statute is to help protect your morals, or something like that. In any case, it's not to prevent fires. And so the negligence per se doctrine would not apply. So that completes our discussion of breach. To run through it one quick time: violation of rules of conduct, negligence per se doctrine. And it has to be a criminal statute, not a city ordinance. The purpose of the statute has to be to protect this type of plaintiff against this type of injury. If you've got that, it's negligence per se. The court won't even hear evidence of non-negligence. This has to be an unexcused violation of the statute, by the way. Sometimes one can violate a statute, but the violation would be excused. For example, if a person was driving their car and they saw near a park and they saw a ball run out in front of them and a child chasing after the ball, and they went across the double line and on the wrong side of the street to keep from hitting the child, but caused an accident in doing so, I think most people would say that was an excused violation. And so it has to be an unexcused violation of an applicable criminal statute, results negligence per se. Otherwise, violation of company rules, city ordinances, community custom, that sort of thing, you get evidence of negligence. And since now you only have evidence of negligence, be sure to get the rest of the points by pointing out what evidence there is of due care, and the other side will offer that evidence of due care, and the jury will hear both sides: evidence of negligence, evidence of due care. Tell them what the standard is. Tell them who has the burden of proof, the plaintiff. Standard is preponderance of the evidence. Say what you think the outcome would be. Violation of the standards of professional skill, we had the plumber balancing test. We had a couple of examples of that. Reasonableness, it doesn't get tested, but if you have a case, throw it in there. And res ipsa, we have two examples of res ipsa. This was the trains that don't come off tracks unless somebody most likely was negligent. And the other example was the car who didn't make the turn, hit the power pole, doesn't know why it happened. Okay. So this is how we would establish breach, and those are some good examples of it. What we will do now is to take a short break. When we come back, we will pick up with causation.